Good afternoon, and thank you for joining us for an MP webinar on preventing wrongful termination and discrimination lawsuits. I'm Amy Lehman, Head of Marketing here at MP. And for those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of solutions to support organizations through the entire employee life cycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today, Andreya DiMarco from the Hatfield Schwartz Law Group. Andrea's practice focuses on representing employers in all aspects of employment law, as well as advising clients on proper compliance with the law to mitigate liability. While litigation is a central component of Andrea's practice, she also advises clients on daily issues related to policies, personnel matters, discrimination, harassment, retaliation leave, wages, accommodations, and compliance. Hatfield Schwartz is a woman-owned law firm located in northern New Jersey with a practice centered on labor and employment law. Founded by Stephanie Schwartz and Catherine Hatfield in 2020, the firm provides dedicated personal attention to each one of their clients. They develop proactive business solutions, assisting clients with all of their legal needs. For more information, please visit their website, hatfieldschwartzlaw.com. And just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. And we will be sending out a recording of the webinar along with the slides on Monday. And with that, I'm going to hand the mic off to Andreya.
Good afternoon, everyone. Thank you for being here today. So, as discussed by MP, today we'll be talking about best practices for preventing or at least mitigating liability in connection with discrimination and wrongful termination suits. So we'll be discussing the law a little bit and then going over best practices, your responsibilities, how you can try to prevent these suits or at least manage them, consequences of a lawsuit and how you should handle it once it is filed. And then, as discussed, if there's any questions, I will try to get to them at the end. If I cannot get to your question, I will try to contact you after this webinar and provide you with an answer or discuss it further with you. Okay, so let's start with a little overview of the law. Certainly cannot prevent these type of lawsuits or mitigate your liability if you don't understand what the law is or what it says. So we'll start with discrimination, as we have seen a huge flux of discrimination claims over the last few years. And Title VII, which is your federal law of the Civil Rights Act, prohibits discrimination based on an employee's race, color, religion, gender, or national origin. And in connection with employment matters, it prohibits it in basically any employment action, and we'll discuss it a little bit further. So hiring, termination, compensation, benefits, positions, so promotions or demotions, and other action that you take against your employees. I'm going to say every single state in this country has their own discrimination or anti-discrimination and anti-harassment laws. So you should certainly make sure that you are familiar with what the law says in your state. I know, for example, in New Jersey, where I'm based, the law is more expansive than the federal law, than Title VII. So in New Jersey, discrimination and harassment are prohibited based on not only race, color, religion, gender, and national origin, but also on other categories or protected categories, including disability, perceived disability, sexual orientation, marital or civil union status, pregnancy, and military status. So again, you want to make sure that you are reviewing your state laws and you are familiar with what your state law says, because it very well may be more expansive than what the federal law requires. So what are the types of discrimination claims that can be brought? These are the most common ones that we see: a failure to hire, claims based on discriminatory harassment in the workplace, a failure to promote, other types of adverse employment actions, so demotion, pay, that's you're paying somebody differently based on their protected category, protected class, the way you treat the employee, overall general treatment, so a hostile work environment claim, and different opportunities that are prevented. So we'll break this down a little bit and then we'll get into wrongful termination a bit more. So a failure to hire, this can arise early on, of course, failure to hire. So you have to be careful of not only your application process, but your interview process. So things you want to be aware of and practices to avoid any sort of failure to hire discrimination claim is making sure that your application does not have anything in the application that could be seen as discriminatory or could be used against the employer in asserting that they have acted in a discriminatory manner based on how the application was filled out. So, for example, including any sort of disability-related questions or medical-related questions. If you have that on your application, unless there is some sort of reason that you need that in the application based on the type of position, that could be used against you as an employer. So if an employee is filling out an application and they check a box that says that they have a certain type of disability or they have certain medical conditions, and you don't hire that employee, or maybe you don't even bring them in for an interview, you're setting yourself up for this person, this applicant, to make a claim against you as the employer that you didn't hire them or you didn't bring them in for the interview, despite the fact that they were otherwise qualified because you were aware that they had this disability. Likewise, with any other sort of potential protected class, so questions about sexual orientation, religion, certainly should not be on a job application. Gender really does not need to be on a job application, again, unless there is some sort of reason, like you are a religious institution and it is a requirement or in line with your religious tenets to only hire people of your religion. Then those type of questions should not be on your application. You want to make sure that you are avoiding any possibility that someone can make a claim against you that you are acting in a discriminatory manner. And that applies to your interviews as well. You want to make sure that the questions that you are asking are in line with the job position, that you are asking questions about the person's qualifications, their experience, anything that will help you determine whether you can or cannot hire this person and whether they are fit and qualified for the job. You should avoid asking questions during an interview that could be seen as discriminatory. So you should avoid asking questions about their religion, again, unless you are a religious organization and there is a need for that question. You should avoid asking questions about their gender. You want to avoid asking questions about arrests or convictions. Most states now have laws that are called ban the box laws that don't allow you to ask those questions on an application or during an interview. So you want to make sure that you are avoiding that. You want to make sure that you're avoiding questions about citizenship status unless it is necessary. You want to make sure that you're not asking them for a photograph before they come in for an interview or in connection with their application. Again, you want to avoid that there is any sort of appearance of impropriety, any sort of implication that you are making a decision that is based on anything other than this person's qualifications and fit for the job. Another thing you want to avoid is asking questions about marital or familial status. We see this a lot. And maybe during the interview, you're just making conversation, but in general, you want to try to avoid asking questions about whether they're married, who they are married to, whether they have any kids, whether they're planning on having kids. Even though you might think you're just making conversation during the interview, this could certainly be seen as being used in a discriminatory manner, that you did not hire them because they are in a civil union status. You did not hire them because they are a female and they're planning on getting pregnant. You did not hire them because they have kids. So again, you just want to make sure that you are limiting your interview questions to questions about the position, their experience, and their qualifications. So harassment claims. These are claims that we often see. Of course, once a person is actually hired, they are employed. So employment claims that are made based on discriminatory harassment. So most states will have their own anti-harassment laws in place that say what is considered harassment in that state. In New Jersey, for example, the law says that it is unlawful to discriminate against someone and that harassment can arise where the terms and conditions of employment have been altered based on conduct in the workplace, and that conduct has to be severe or pervasive, and it has to be based on a protected class. So If someone brings an internal complaint or external complaint saying that they have been treated differently because of their race, or that they have been subjected to demeaning and derogatory comments in the workplace, and that this has happened once a week over a period of 6 months, this can certainly be unlawful harassment and can lead to a discrimination claim. So failure to promote, we see this a lot as well, where someone will bring a claim and say that they did not receive a promotion based on their protected class. So they did not receive a promotion because they are a female. They did not receive a promotion because they are a certain age. They did not receive a promotion because they are a certain religion. So best practices to avoid these type of claims are ensuring that you have a specific criteria in place for a promotion if there is a vacancy. So you want to make sure that your promotion is potentially in writing and it's spelled out that to be eligible for this promotion, you have to have maybe certain education, a certain degree, certain training, certain certifications, certain experience, or certain years on the job in general, or certain years internally with your organization. And you want to make sure that it specifically spells out what those requirements or prerequisites are, so that if someone is not qualified or they're automatically disqualified based on these prerequisites, you have that clearly in writing, or that has clearly been communicated to employees to help avoid an employee making a complaint that they didn't receive the promotion exclusively because of their protected class and not because they were not qualified. Likewise, when you're going through the promotion process, you want to make sure that you're doing it properly. So again, make sure that you are acting in line with whatever criteria that you have set out. Make sure if there are interviews and you're taking notes that someone is not performing well, or they're not qualified for a certain reason, they didn't perform well during the interview, they don't have the experience that perhaps you thought they had, that is well documented, so there's support there for the reason that you have not promoted them. Overall, the goal is to just make sure that you have supportive reasons for why you chose not to promote any of the employees or outside persons that you chose not to promote. As long as you have supportive reasons that can help mitigate any claims of discrimination that are being made by an employee who's stating that they were not promoted because of their protected class rather than because they were not qualified or they didn't perform well during the promotional process. Other types of adverse employment action discrimination claims that we often see are claims for demotion or claims for poor treatment. And we talked a little bit about a hostile work environment. So that usually is where we see this treatment, where someone is saying that they have been subjected to harassing conduct in the workplace, or where they feel that they are being treated differently because of their protected class. So you just want to make sure that you are treating all your employees equally and fairly, and that you are ensuring that the environment is a respectful environment, so that you don't see any claims made by your employees that they are being treated adversely by their managers or by their colleagues. For demotion, we see this often where someone is demoted because they were performing poorly over time. And they are alleging that they were demoted because of their race or their sexual orientation or their age rather than their job performance. So we'll talk a little bit more about this later in the presentation, but in connection with this, you just want to make sure that you are always documenting any performance issues and putting employees on notice. So if someone is habitually late, if they are often not coming to work, if they are abusing PTO policies, if they are just generally performing poorly, they're not getting their assignments in on time, their work quality has suffered and it is not up to par with your organization's expectations, or it has changed over time for the worse, you want to make sure that you are communicating that with the employees and that you are documenting it so that there is a well-supported reason for any decision you made that may be seen as a negative decision about this employee's position or condition or terms of their employment. So the huge claim that we see, and we'll talk about that throughout this presentation, are wrongful termination claims. So what is a wrongful termination claim? It is a claim that is brought by an employee or former employee now that has been either filed in an agency or in a court of law, and the employee saying that they believe that they were unjustly or unlawfully terminated from their job in violation of the law. So usually it can involve state laws, however, it can also involve federal laws. And we'll talk a little bit about the types of wrongful termination claims. If I can get to the next slide. Sorry, having some hiccups with this presentation today. Okay, so common types of wrongful termination claims are discrimination claims, which we've discussed and will continue to discuss. Claims under the ADA or the Americans with Disabilities Act, retaliation claims, huge, we see this very often, whistleblower claims, and claims for taking leave. So discrimination, as we discussed, often discrimination, wrongful termination claims based on discrimination will arise where someone is claiming that they have been terminated solely because of their protected class. So they're claiming that they were terminated because they are of a certain race, or they have a disability, or because of their age. So I was terminated because I turned 60 last year. I was terminated because my employer found out that I am Muslim or I am in a same-sex relationship. So ADA and the Americans with Disabilities Act, you often see claims arise under this for wrongful termination based on discrimination and also in connection with reasonable accommodations. And we'll discuss that a little bit further, but someone will say that they were terminated because, again, they have a certain disability and they put their employer on notice of this disability, or they were terminated because they asked for a reasonable accommodation, and rather than being provided with that reasonable accommodation, their employer decided that they were just going to terminate them. Retaliation is when an employee alleges that they were terminated for complaining about a protected activity. And a protected activity is generally any type of unlawful conduct. So if an employee makes an internal complaint that they feel that they are being harassed by their colleagues because of their race, or they feel that they did not receive a promotion because they are a female rather than because they weren't qualified for the promotion. And then thereafter, after they have lodged this complaint, there's retaliation taken against them. So they lodge this complaint and then 3 months later, they're terminated. You have a very likely case there that someone is going to bring a claim that they were terminated because they have lodged this internal complaint. So they were terminated in retaliation rather than for whatever reason that they were given that they were terminated. So whistleblower complaints, federal statutes that protect this, and most states have statutes that talk about whistleblowers. So I know in New Jersey, we have the Conscientious Employee Protection Act, or a SEPA claim. So what that says is that generally, if an employee, quote unquote, blows the whistle or reports unlawful conduct, whether that's internally or externally, or if the employee refuses to engage in conduct that they believe is unlawful or that they believe is in violation of public policy, and then their employer terminates them after they have raised this concern or after they've objected to or refused to participate in this allegedly unlawful conduct, they can bring a claim under whatever whistleblower act you have in your state saying that they were terminated because they, quote unquote, blew the whistle or refused to participate in this activity. So wrongful termination claims under leave laws. So as most of you I'm sure know, the federal leave laws, FMLA, Family Medical Leave Act, and most states have their own family and medical leave laws, which require employees to provide a certain amount of job protected leave and to follow certain procedures. So often we will see that an employee was terminated while they were on leave or shortly after they returned for leave, and then they bring a complaint saying that they were terminated because they took this leave, not because of the reason that they were allegedly terminated for. So let's break those down a little bit more. And we touched upon discrimination laws and the ADA. So what do you need to know about the ADA? You need to know that it prohibits discrimination against an employee because that employee has a disability. It also requires employers to provide reasonable accommodations to employees unless the accommodation would cause an undue hardship. So there's a set of standards for what is considered an undue hardship, and it is determined on a case-by-case basis. But generally, it is a financial hardship. So if the employee is asking for a certain accommodation, like a elevator is installed in the building or a ramp is installed, and it is a small employer and they cannot financially afford to install this, then they may not be able to provide that accommodation. However, unless there is an undue hardship to the employer, you generally are required to provide this accommodation. And likewise, you are required to engage in what is called an interactive process with employees. So an employee is alleging that they have a disability and they need an accommodation to perform the essential functions of their job position, you need to engage in an interactive process with that employee. So you need to sit down, talk about what the employee's limitations are and what potential accommodations may or may not be able to be provided by the employer so that the employee can perform the essential functions of their position. You don't need to make a decision during that interactive process meeting. The decision can come thereafter once you've evaluated what the limitations are and what accommodations may or may not be provided. But you do need to make sure that you are going through these steps. And often we will see that an employee will ask for an accommodation and this step is skipped. An interactive process is not held. The employee just immediately determines that they can't provide this accommodation and then lets the employee go. This can cause a wrongful termination lawsuit to arise and other claims to be brought under the ADA that you did not engage in the procedural requirements under the ADA. So again, you want to make sure that you understand what the law says, not only the substance of the law, but any procedural requirements under the law, and that you are complying with those requirements to avoid any sort of claims being brought against you, not just wrongful termination claims, but other claims that you are violating this law. And we often assist our our clients with this process. So when in doubt, consult with your legal counsel. Consult with your legal counsel as to whether you are following the law, what procedures you need to be taking, whether you are properly following those procedures, and whether you do or do not need to provide these accommodations to employees. So leave laws, and again, we touched upon this, so let's expand upon it a little bit more. So Family Medical Leave Act. The Family Medical Leave Act is your federal law. And as long as you have 50 or more employees within a 75-mile radius, you are required to comply with this law. So what it says is that you must provide eligible employees with up to 12 weeks of unpaid job protected leave in a 12-month period for any qualifying reasons. So the key there is job protected leave. What this means is that you cannot terminate this employee while they are on this medical or family leave. It also means that you are required to essentially hold their position open. So you don't have to hold their exact position open, but when their leave is expired or when they are coming back from leave, you do have to ensure that you are either returning them to the same position or to a similar position. So similar meaning that it has similar compensation, benefits, and job requirements or job duties. You want to make sure that you are, again, providing that job protected leave. Often we see that an employee is terminated while they are on leave, or they are terminated shortly after they return because the employer could not hold that position open. They filled the position and then they didn't have somewhere else to place the employee. And then the employee will turn around and bring a wrongful termination lawsuit against the employer. So you just want to make sure, again, that you not only understand the substance of the law, what you have to require, but the procedure and what you have to be doing. So holding the job position open and or returning the employee to a similar position. You also want to make sure that you know how to handle these requests for leave. So ensuring that you are following the proper procedures. So putting the employee on notice to begin with that they are entitled to this leave. Ensuring that if the employee is being provided with the proper forms under this leave so that you have those forms in your possession and that you are maintaining proper documentation of what the employee has taken and has not taken, and that you are putting the employee on notice of how much leave they're eligible for, that they are entitled to job protection, that you're going to continue to provide benefits during this time and all the other requirements under the law. Just want to make sure that you're always following the proper procedure to help mitigate any liability and any claim being brought against you as the employer that you are in violation of the law. So some other things to consider, what we see often, and this is where you may want to consult with legal counsel if this arises, is that an employee may say that they need to take leave for 8 weeks. They are then on week 6. You as the employer check in with the employee to find out their intention to return to work, and they ask for an extension of leave. So you want to make sure that you are handling that extension properly. And that will depend on how much leave they are requesting. Are they still entitled to it? What are they entitled to? And ensure that you are, again, handling those leave requests properly in accordance with the law. Often we see that leave will be exhausted. So they've now taken their full 12 weeks and they are still seeking additional leave. You want to make sure that you know how you can handle that and what the implications are. So if an employee has taken all leave under the Federal Family and Medical Leave Act, all 12 weeks, and they still need an additional 4 weeks of leave, what you want to do is first look at your state leave laws to determine whether there is any medical or family leave that you are required to provide under your state laws. And if there is not any leave that you are required to provide under your state laws, you want to look to the ADA. So if the employee is on leave for a reason that falls under the ADA, so typically a disability, you may be required to provide them with additional leave under the ADA. It can be considered a reasonable accommodation. However, that is handled on a case-by-case basis. So again, this is really important that under these circumstances, you are consulting with legal counsel to determine how you should be handling this. Should you provide more leave? Are you required to provide more leave? And if you are required to provide more leave, are you required to continue to hold this employee's position open, or can you fill the position? If you aren't required to provide more leave, what steps do you take next? If the employee says that they are not returning to work, is this considered a job abandonment, or is it considered a termination? Again, it is a case-by-case basis. It depends on the circumstances. It depends on your state leave laws. Oftentimes, if you are saying you can't provide more leave, and the employee still needs leave, that may be considered a termination. So do you now have a potential claim on your hands where the employee might turn around and challenge what you are doing and challenging it as a wrongful termination? So again, you want to make sure that you have all proper documentation in place that shows that you provided all the leave required to be provided under the law. Here's the documentation showing that you provided it, that the employee still needed leave, and that you have taken the proper steps to ensure that you have complied with the law and that the employee has exhausted all leave. There's nothing else that you need to be doing legally. That doesn't say that you're going to be fully insulated from a claim. Unfortunately, sometimes employees can be litigious and you may still have some exposure. But the best way to protect yourself as the employer is to ensure that you have followed all procedural requirements and complied with the law. Okay, so did I skip a slide? Some best practices to avoid wrongful termination claims, as we discussed, is understanding the law and ensuring that you are complying with the law. So you certainly cannot avoid claims or prevent or mitigate liability if you don't understand what the law says and what you as an employer are required to do and what you don't have to do. So it's making sure that you have a proper and thorough understanding of any of these laws. So all your discrimination laws, your harassment laws, your leave laws, any whistleblower laws, any laws that could be challenged as a violation in connection with any adverse action that's being taken against an employee. You want to make sure that you have a full understanding on those and a hold of those and ensure that you are complying with the law. You want to make sure that you are properly communicating with your employees, and we'll touch upon this a bit further, that you have proper policies and procedures in place, and we'll get into that a little bit more, that you are enforcing and complying with those policies and procedures, and that your employees, particularly your supervisors, your managers, any upper level employees, understand what those policies are. They are enforcing them, they are complying with them. And make sure that you are properly managing internal complaints. Talk about that a little bit more. That you're properly documenting employee performance, any incidents, attendance issues, document. We will touch upon this more as it is so important. And that you are consulting with legal counsel anytime that you feel it is necessary. So if you don't know that you're complying with the law correctly, if you're unsure of what the procedure is under the law, if you're unsure of how to manage or handle a personnel issue, always touch base with your attorney so they can help walk you through it. So we'll start from the top again. So communication with employees. This is important that it can help mitigate liability, because sometimes avoiding a complaint or avoiding a challenge is as simple as just communicating properly with your employee and clearing up any sort of miscommunication. So where this may arise is if there was a vacancy for a promotion and a certain employee did not receive that promotion and now they're upset. Maybe it's just having a meeting with that employee and explaining to them why they were not promoted, explaining to them that they didn't have the proper training, that they didn't have enough experience, that their job performance recently maybe is not up to par, that they have been absent a lot, or that they are often late. Sometimes it's just as simple as communicating to them, like, this was why we did not choose you, and this was why you were not promoted. Unfortunately, you just were not the best candidate. That may help the situation. However, caveat, if you are going to sit down and have those conversations with employees, always recommend consulting with legal counsel before you have those conversations to ensure that the conversation that you're having is proper and that you are not saying or doing anything that may open yourself up to further liabilities. So yes, proper communication with employees, but ensuring that you are doing it correctly and properly. We'll talk a little bit more about employee handbooks, policies, procedures, and how this can help mitigate liability. So every handbook, always recommend having an at-will employee statement in there, as long as that is in compliance with your state laws. So at-will language says that all employees are at will unless they are subject to a CBA or to an employment contract that states otherwise. So at will means that you as the employer generally have discretion to terminate them at any time for any reason. And this just provides you as the employee with further protection against any sort of wrongful termination claim, because you maintain that discretion to terminate your employees. You want to ensure that your employee handbooks have proper laws in place and that you are complying with those laws. So again, and we'll touch upon this, you want to make sure that you have any equal opportunity statements in there, harassment and discrimination laws, reporting policies, all laws that show that you are complying, or all policies, that show that you are complying with all applicable laws and that you follow these laws. You want to make sure that you're setting forth your procedures, your requirement, your expectations, your guidelines. So for example, if you have strict attendance policies in place, if you need your employees to be in by 8:30 a.m., tardiness is not acceptable. It is important for them to be there. You want to make sure that you have policies in place that delineate this clearly. Employees are expected to be at the work site by 8:30 a.m. Any tardiness past 5 minutes will be considered tardy and will be documented properly so that employees understand what the expectations are. And there is a written policy that says that this is what the employer's expectations are, and this is what the employee must do. If they're violating those policies, they certainly are subject to discipline, and those could lead to termination. So you want to make sure that your policies don't have a discriminatory impact. So an example of this was reviewing a policy once that was a maternity leave policy, and it was strictly offered or strictly directed towards female employees. And while it was mostly meant for employees who gave birth to be able to have some time to recover from that birth, it was not written in that way. It was written that an employee, a female employee, could take X amount of leave following the birth of a child. But it did not say that that leave was only for disability reasons or only to recover from the birth. The way it was written, it would allow the employee to also take leave to bond with the child or to care for the child. And since it was only applicable or only directed towards female employees, it had a discriminatory impact, even though that was not the employer's intention. So we had to revise the policy accordingly. So you want to make sure that any policies that you have in place, even though you may be acting in good faith, even though you may be trying to provide your employees with some really great benefit that maybe other employers don't provide, make sure that those policies do not have a discriminatory impact, because they could certainly be challenged and be used against you in a discrimination claim. So you want to make sure that your handbooks are always distributed to all employees and that they are signed. So you want to make sure that you have an acknowledgement form in your handbook. The employees sign that and return that to you as the employer, so that it is clear and there can be no challenges that the employee was not aware that these policies were in place. They're aware of all the policies, they are aware of the procedures, they are aware of what they can and cannot do. You want to make sure that your handbooks are being regularly reviewed by counsel to ensure that they are compliant with the law, they're up to date, and that they have the best procedures in place to ensure that you are insulated from liability and that you are acting in accordance with the law. So you want to make sure that you're maintaining these certain policies. Again, equal opportunity employer policies, harassment and discrimination policies. Always make sure that you have those in your handbooks to show that you are aware of these laws and that you comply with these laws, and that you certainly do not tolerate discrimination or harassment in the workplace. You want to make sure that you have proper reporting procedures in place so that employees understand what their avenues are and what the procedure is. So if an employee feels that they are being discriminated against, they're being harassed, if they feel that there is some sort of unlawful conduct occurring in the workplace, they know who to report to, how to report, and what the procedure looks like. Again, family and medical leave laws, you want to make sure that those are in your handbook so employees understand what their rights are and are not under the law. Some employees may think that they are entitled to more leave than they are actually entitled to. So you want to make sure that you have clear policies that set forth what the leave laws are, that you comply with those laws, what the employee's responsibilities are in terms of giving you notice and in terms of following the law, and what your responsibilities are, and any additional leave that you may provide. So if you're required to provide sick leave under law, make sure that that is in there. If you as the employer are generous and have additional leave policies, you want to make sure that that is clearly spelled out or not spelled out. You want to make sure that employees are aware that if they exhaust all leave, they won't be entitled to any additional leave, that you as the employer do not provide this additional leave. And therefore, if the employee cannot return to work, that is not going to be a wrongful termination claim. They have exhausted all leave that's available to them. They are not entitled to any more. If they cannot return, that is essentially on them. You want to make sure that you have proper drug use and testing policies in place, and these are really state specific. So ensure that you are clear on what your state law says, particularly as we see recreational marijuana being approved from state to state. You want to make sure that you are now in compliance with any policies under the laws that say how you can and cannot treat employees in regard to their drug use and in regard to any sort of workplace drug testing. Again, just avoiding any sort of challenges that you are not acting in compliance with the law and that you terminated someone unlawfully. As we touched upon, you want to make sure that attendance policies are clearly spelled out. So any procedures regarding attendance. So if your employees are required to notify a supervisor or a manager by a certain time that they will not be in that day, you want to make sure that that is clearly spelled out in your handbook so that employees know what they are required to do, and that if you have a recurring issue with an employee, you know that you have a clear policy in place and that employee has been clearly violating this policy. Discipline policies, you want to make sure that those are clearly spelled out in your handbook. However, you do want to make sure that you are careful with the language that you are using. So if you are going to have some sort of progressive discipline or a 3 strikes type of policy that says that upon a first infraction, an employee will receive a verbal warning. Upon a second infraction, it is a written warning. And upon a third infraction, employee may be subject to termination. That is certainly fine. You can have those type of policies. However, you want to make sure that you always have language in there that you as the employer maintain discretion to handle cases or to handle incidents on a case-by-case basis, and that you maintain discretion to terminate an employee or to skip any of those steps if you feel that it is warranted. Likewise, with termination policies, you want to ensure that you as the employer maintain discretion to terminate an employee at any time, unless, of course, they have a CBA or they have a contract that states otherwise. We touched upon this a bit, but complaints, reporting, and investigation. It's really important to make sure that you have proper complaint policies and procedures in place. Why is this important? Because if an employee is making a complaint that they have been subjected to harassment or discrimination, you will help insulate yourself from liability or mitigate liability if that complaint is being properly addressed in a timely manner. So you want to ensure that employees have an avenue to report these complaints internally and that it is clear of how these complaints will be addressed. You want to make sure that the employee knows that their complaint is being taken seriously and that they have been heard and that you as the employer are addressing it. So meaning that the policy states who the complaint should be reported to, and it ensures that it will be addressed in a timely manner and confidentially. So if someone brings a complaint, an employee brings a complaint that they feel that they are being harassed by colleague X in the workplace, this has been going on for 6 months, you as the employer should be investigating that. So that might mean interviewing the complaining employee, interviewing the alleged perpetrator, and ensure that you are taking action and steps to address this complaint. If the complaint goes unaddressed, you're setting yourself up for liability that they are going to bring a discrimination claim against you because they have now put you as the employer on notice that they are being subjected to harassment or discrimination in their workplace, and you are not addressing it properly. You are just turning an eye to it and letting it move forward. So you want to make sure that you have proper procedures in place and that those procedures are followed. This will also help you if a lawsuit is later brought. You can then use this as a defense to say, this was brought to our attention, we investigated it, and this is what we found, and this is the action that we took. We, terminated the employee that was the perpetrator, or we found that there was no substance, or these claims were not substantiated. Again, you just want to make sure that you are following any procedures that are in place and addressing any claims that are brought to your attention. Also, it helps ensure that if a claim is not brought to your attention, that you were not unaware of it. So if an employee is saying that they were subjected to harassing conduct, there's a proper complaint procedure in place. The employee knows this complaint procedure is in place, yet they neglected to bring this complaint forward. That helps you as well, because if they then bring a claim, you were not on notice as the employer, so how could you have addressed this? Documentation. Cannot stress this enough, and I think I've mentioned it throughout this webinar today. You want to make sure that you are always, always, always documenting. So this will be the biggest way to help mitigate any liability if a lawsuit is brought. So if an employee is terminated because of their performance, if the employee is not performing up to par, if their work quality is poor, if they are consistently tardy, if they are absent more than your policies permit, you want to make sure that this is properly documented. And we see this very, very often where an employee is terminated for lawful reasons. They are terminated because they are not performing well. They are not a good employee. They're not proactive. Their work quality is poor. They are often late. They call out all the time. However, the employer has not documented this. So there's no proper paper trail, I'm going to call it, that shows that, there's been X amount of incidents. This was addressed with the employee. There were conversations with the employee. The employee was put on notice. They were warned about their performance. They were warned about their attendance. And regardless, they continued to be late. They continued not to show up to work. Documentation is so important. It will help protect you as the employer to show that you have supported reasons for terminating this employee. And that goes for verbal conversations as well. So if you have a conversation verbally with an employee because they've now been late for the 3rd time this month, make sure that you're documenting that. Put a memo in the employee's personnel file. On X date, I had a conversation with this employee. I informed that they've been late 3 times already, that this is a violation of our policies. And if they continue to be late, discipline will be pursued, including or up to termination. They advise that they understood. Put a note in the file or have the employee sign off that you've had this conversation with them and that they understand. The same with performance concerns. You don't, under the law, have to have performance reviews every 6 months or every year. However, they can be really helpful. And if you are going to have them, make sure that you're documenting them, particularly if there are concerns about an employee's behavior. Make sure that you are detailing what those concerns are, that you've put the employee on notice of these concerns, and that expected that the employee will perform better moving forward. Otherwise, there may be adverse consequences. And as we touched upon, attendance issues, again, an employee is habitually late, they're violating any sort of PTO policies, you want to make sure that you are documenting this. Document any sort of infractions, complaints, performance issues, attendance issues. You want to make sure that you have support so that if a claim is brought that you have acted adversely against an employee, that you violated the law, that you've wrongfully terminated an employee, you have proper support to show that these are the reasons that you terminated this employee. Consult with legal counsel. So whenever you are in doubt, you want to make sure that you are consulting with your attorney. So ensure that you're consulting with your attorney about compliance with laws. Ensure that you're consulting with your attorney to make sure that you are following proper procedures, or that you have the best procedure in place to handle personnel issues, to manage personnel issues. You want to make sure that you are consulting with your legal counsel if an incident arises. So if there's a personnel issue that arises, if there's an incident arises, if someone is, again, if there are performance issues, someone's habitually late, or there has been an internal complaint made, make sure that you're consulting with your legal counsel on the best way to manage and handle these issues. Likewise, and we touched upon this with leave requests, if you have an employee who is looking for extended leave, you want to make sure that you are managing this properly under the law, that you're complying with all federal laws and with all state laws, including the ADA, and that you are handling that leave request properly to help avoid any sort of complaint or lawsuit being brought against you, that you did not handle the leave request properly, that you violated the law, or that you wrongfully terminated an employee while they were on leave. Likewise with discipline, if you need to discipline an employee, make sure that you're consulting with legal counsel to ensure that you are doing it properly and that you are doing it in the best way possible to help avoid any future litigation and any future claims being brought against you. Termination, if you do decide that you need to terminate an employee for whatever reason it is, consult with your legal counsel. Ensure that you are doing it properly, that you are handling it the best way possible to avoid any sort of wrongful termination claim being brought against you. And you want to make sure that you are always understanding any possible exposure. So consult with legal counsel if for nothing more than for that. They can tell you what your potential exposure is and how you are handling this. So if you are going to terminate an employee and you have decided that doesn't matter, no matter what, you were terminating this employee, you have had enough of their performance, their tardiness, whatever it may be, at least your legal counsel can tell you that, okay, you're handling this properly. However, this is the potential exposure. There could be a potential claim brought because of A, B, or C. So consequences if a lawsuit is brought against you. If anyone has been a part of a legal claim, they know that it can be exhausting. It takes up money, it takes up time, it takes up resources. It is time that you are now utilizing towards this lawsuit rather than towards your job duties, rather than towards your personal life. It is just time consuming. There's a lot that goes on in litigation, depositions, discovery, so a lot of meetings. It is very time consuming, and there's unfortunate consequences that are associated with that. So the goal is prevention. The goal is to make sure that you are doing all that you can to minimize legal liability, to prevent any wrongful termination claims from being brought, that you don't have to deal with that litigation. However, if litigation is brought, you just want to make sure that you are, of course, consulting immediately with your attorney on how to handle litigation and the steps that you need to take. So maintaining confidentiality, that means don't speak to employees that you shouldn't be speaking to about it. Make sure that if the employee who brought the claim, if it's not a wrongful termination claim, if it is just a discrimination claim, if the employee is still working for your organization, that you are now very careful with how you are treating this employee, so that they do not then say that you are retaliating against them because they brought this lawsuit. So again, consulting with legal counsel to make sure that you are handling any personnel issues that may arise thereafter with this employee correctly, to avoid any additional claims of retaliation or other claims that the employee may bring. Make sure that you are preserving and turning over any documentation in connection with this action to your attorney. Of course, if a lawsuit is filed, your attorney will walk you through all of this. Okay, I can't see my screen, but some takeaway from today are making sure that you understand the law and that you are complying with the law, and that means the substance and the procedures of the law. Make sure that you are maintaining handbooks and proper policies that set forth the law, set forth that you are complying with the law, and that set forth any procedures or policies that you as an employer have in place that your employees need to follow, so that your employees understand what they can and cannot do and what their rights are and are not. Make sure that you are documenting. So always documenting any performance concerns, any attendance or tardiness issues, any incidents that have arisen, anything that will help support your reasoning for having to terminate or take adverse action against an employee. Make sure that you are communicating, so communicate properly with your employees and communicating with legal counsel. Make sure that you are properly training your management, your supervisors, and your HR departments, so that they understand the laws, they understand the policies that your organization has put into place, they understand how they are to handle personnel issues, whether that's complaints, investigations, requests for leave, the like. Make sure that you have internal training with them, bring in counsel if you need to. And as we have said throughout this webinar, make sure that you are always consulting with legal counsel when in doubt, so that they can guide you and walk you through the proper way to manage any personnel issues, any complaints, and any potential lawsuits that may be brought or that have been brought. Okay, so there are some questions and I will answer a few, and then I'm going to wrap up here. So anything that I don't get to, I will always touch base with you afterwards. And if you have any additional questions, feel free to reach out. Just give me a minute to read some of these. So if someone brought a complaint about a manager, are we required to interview the manager as part of the investigation? I wouldn't say that you are required to, but I would suggest it. If someone is bringing a complaint and there is substance to that complaint, the best way is to interview or speak with the complainant to ensure that you understand everything they're complaining about, what has occurred, when has it occurred, how many times has it occurred. And then you do want to speak with the manager. You want to make sure that you are getting their rendition of events to see what they have to say about whatever complaint is being brought. You know, did this actually happen? Are they admitting it happened? Are they denying it? You want to make sure that you have a full picture of what has occurred so you can properly handle it. And if there's any witnesses that have observed any of the events that the complainant is complaining about, you may want to speak with them as well. Of course, you want to ensure that you are doing this confidentially so that there is not gossip in the workplace and so that other employees are not being brought in that don't need to be brought in, but you do want to make sure that you are doing a thorough investigation. So that would involve interviewing the complainant and the alleged perpetrator, as well as any potential witnesses. And again, if you are unsure of how to properly handle that investigation, you should consult with legal counsel and they can help walk you through it. So if an employee provides a doctor's note about a restriction for a work-related strain injury, but doesn't ask for an accommodation, and we ask if they need an accommodation, they say no, even though the note suggests they would, could we be considered not complying with the ADA? And if they are laid off, could we be in danger of a wrongful termination? This is a fully loaded question, so I think this would be a little bit, it depends on what the injury is, what the accommodation would be, and you mentioned that it's a work-related injury, so that could bring in other potential legal issues and concerns. If they have an injury and they can't perform their job without an accommodation, then you should probably be providing that accommodation as long as you can. If they are refusing to use that accommodation, then their refusal should be documented. And if their refusal to use it is resulting in them not being able to perform the essential functions of their job, then again, I think the best thing is probably to have a conversation with them about that, you're offering this accommodation. It appears that they cannot perform the essential functions of their position without the accommodation, yet they are refusing to use the accommodation. Therefore, they are refusing to essentially perform their job. They need to either use this accommodation or they could be liable for termination since they are unable to perform the essential functions of their position. It's hard to say with this question what the details are and how that would be handled, but you want to make sure that you have all the proper steps in place and that you are following those steps. If someone is essentially not able to perform their job and they're refusing to perform their job, then you certainly could terminate them because they are not performing. But again, you want to make sure you're taking all proper steps first to help mitigate any liability. If a verbal warning was given to an employee and a written record of this verbal exchange is written down and placed in an employee's file by the manager and HR, does the employee need to be given a copy of the written internal documentation? So generally, no. Again, check your state laws, although I don't know of any state law that says that this is required. They don't need to be provided with a copy. However, you should probably put them on notice that you are documenting it and that is going in their file. It's always helpful to have an employee sign off. That just helps give you further protection that the employee saw that this warning was in place. They signed off on it. They were aware of it. There's no conflict or there's no challenges that this was the conversation that did in fact take place. But to answer your question directly, you are not required to give them a copy. Okay, we are at about 2 o'clock, so I am going to wrap up here. If there's any questions that were asked that have not been answered, I will try to reach out directly. If there's any additional questions that someone may have, please feel free to contact me directly, and I will try to answer them as best I can or touch base with you. So thank you everyone for your time today, and I hope everyone enjoys the rest of their day. I will.
Hey, thank you, Andrea. That was a lot of great information on a complex topic. So if you'd like more information, please visit the Hatfield Schwartz website. For any HR and payroll questions, please set up a meeting with an HR and payroll specialist on the MP team. Please be sure to join us next Wednesday on the same day and time for our very popular HR legislative update to find out everything you need to know about regulatory changes in 2023. Thank you for joining us today and have a great day.